Hello friends, I am Dr. Mohammad AFTAB ALAM. Today I am going to present about the disciplinary proceedings. As I have mustered my experience for the last 7 to 8 years being in various capacities as part of the disciplinary matters, I have tried to encapsulate my experience in few bullet points. That is what I am going to present here. As I can understand that most of the executives like me, they feel very much difficult to execute the disciplinary matters. As a beginner, I had to face a lot of difficulty when I was assigned with the task as a disciplinary authority. So, by virtue of that experience and experience of working with legal experts and having referred to the various legal documents, the Constitution of India, various you can say rules and regulations, so I have tried to encapsulate my presentation in simple steps which will give a clear idea to a beginner or a lower level executives to understand how to take up the disciplinary proceedings. I am going to discuss my presentation in 4 frequently asked questions. Number 1, what does it mean by disciplinary proceedings? Number 2, why is it important? Number 3, what are the objectives? And last and the most important is how to do it. What does it mean by disciplinary proceedings? In simple terms, disciplinary proceedings are systematic processes of inquiry to address the matters pertaining to certain code of discipline. Here it is to note that disciplinary proceedings are systematic processes means that there are certain step-by-step actions that are laid down and which are required to be followed to inquire into the fact about certain misconduct or mishappening. So this is about disciplinary proceeding. Second question that is frequently asked is, why is it important? It is important because if we fail to observe the proper procedures, either willfully or through negligence, it is liable to vitiate the entire proceedings, rendering them null and void. So it is very crucial for us to understand the entire procedures. Most oftenly we find that various judicial pronouncements, they consider various judgments and decisions by the employer against their employee in terms of their dismissal, termination and removal. They do not consider them acceptable. They reject the entire disciplinary action just due to the flawed procedures. And what happens at the end of the day, the time, resource and money all together is spent to conclude a disciplinary matter go in vain, and the management has to bear a great deal, a lot of implications because of the failure to observe all these procedures. That is why it is very important to understand the step-by-step procedures of disciplinary proceedings and to follow it very meticulously. The next question, what are the objectives? The manifold objectives are there behind disciplinary proceedings. The first one is to find out the fact. The second we can call to discipline the staff. Next is to enforce discipline in organization, to remove the flawed part in the system. At times, just by virtue of disciplinary proceedings, we come across various flawed systems of procedures in our system, and then we try to rectify and correct those systems. Next is to protect the weak and the exploited. This is very important that, for example, the worker or the deprived section, women, for example, they are weaker sections. So the judicial proceedings aim at protecting them from unfair, trial or you can say judgments against them. And last and the most importantly, to restore the trust of employees in the system. It is very important. So and so on. There could be various objectives behind disciplinary proceeding. The next frequently asked questions, which is most important, is how to do it. So I'm going to discuss in simple terms, step by step, that I have tried to jot down, and it will give an idea to the friends like me how to execute the disciplinary proceedings. So I have tried to simplify the entire proceedings into three main parts. You can say in three steps. The first stage, we can call it pre-stage. The second is the main stage, and the last or the third one is as we call it, a concluding stage or a last stage. Pre-stage. What happens in pre-stage of disciplinary proceeding? The pre-stage of the proceeding start from as soon as any misconduct takes place and it is reported. It is reported to the concerned official or officer in charge, or the concerned, you can say, head of the department, or the concerned manager, whatever. The second stage it comes, in pre-stage, there is preliminary investigations, wherein the collection of witnesses and evidences are there. The evidences and the relevant witnesses are collected. Then, in line with the act and the witnesses and evidences, the gravity of the misconduct is analyzed, and with reference to the existing code of conduct. That is very important. Each and every organization has certain rules and regulation which is codified, and which is, you can say, the constitution for the organization. It is a Bible, you can say. It is a Bible for the organization. It has to be followed. So that gravity is to be analyzed with reference to the existing code of conduct. And when it calls for penalizing the doer or the delinquent employee, then when it is established that certain gross misconduct has taken place, and that the person or the doer needs to be penalized or punished, then it is required to look for an authority who will serve the, or you can say, the notice, or who can penalize. I mean that this very important aspect in pre-stage is deciding about the disciplinary authority. Who is going to be the disciplinary authority for the matter, and who is competent enough to penalize that particular delinquent employee or the charged official. So in the pre-stage part, we come to know that the certain misconduct takes place, and it is reported, and the evidence and witnesses are collected, and when it is established and when it is decided or confirmed that now the penalty is to be imposed, or because the matter, or you can say the misconduct is very serious, then we appoint or look for an authority, disciplinary authority, who will serve that notice, charge sheet, or you can say punish the particular employee. So this is the background. You can say it is pre-stage. Now the main stage. Main stage starts from the drafting and the drawing of the charge sheet. The charge sheet is a very serious and a very, you can say, very serious document which needs to be drafted with lot of diligence. It should be drafted with reasoning. It should be a reasoned order. The disciplinary authority has to take a lot of pain in drafting the charges in line with the code of conduct, and the looking into the acts done by the delinquent employee, and then in support of all these, all evidences and witnesses are to be enclosed with that charge sheet. Now, after that, the disciplinary authority will issue the charge sheet to the delinquent employee, and after issuing that, in that charge sheet itself, the disciplinary authority solicits the reply from the delinquent employee against that charge sheet within a specified period of time. And now here it is very important that disciplinary authority is supposed to give ample of opportunity to the delinquent employee to submit his reply. So this is very important. And if according to the reply submitted by the delinquent employee, the charges are proved, then the disciplinary authority is empowered to act accordingly. And if the charged official does not accept all those charges mentioned in the charge sheet, then it is required on the part of the disciplinary authority to initiate inquiry. Now, initiating inquiry is itself a process which starts from a very important task, that is appointing inquiry officer. Inquiry officer is the person who can be appointed from inside the organization, or it can be appointed from outside the organization. It can be the legal expert, retired professionals, or the ex-servicemen and so on, who has dealt in the past various disciplinary matters, who have a lot of experience in dealing with all these matters. So now the inquiry officer is appointed by the disciplinary authority. Inquiry officer is called quasi-judicial, you can say, officer. So it is the inquiry officer has to conduct the whole hearing process very meticulously or very sincerely, giving both the prosecution and the defense equal opportunities and ample of opportunities for their submission. Here, after listening to both the prosecution or the defense, both the parties should be given opportunity to cross-examine, and after cross-examination, and the inquiry officer eventually will submit a report to the disciplinary authority. The disciplinary authority, after finding the report from the inquiry officer, may agree or disagree. If the disciplinary authority agrees, it's okay, the process will continue accordingly. Otherwise, if the disciplinary authority does not agree with the report submitted by the inquiry officer, the disciplinary authority with a speaking order may remand the report to the inquiry officer back for a review of the report. So this is the procedure, and after finding the report by the inquiry officer wherein when charges are proved, then the disciplinary authority will give a final opportunity to the delinquent employee to submit his or her reply against that report. And after that, the disciplinary authority will pass a speaking order in line with the inquiry report, and then that penalty is to be served against the delinquent employee. So this is about the procedure. And the last stage, which is about the, you can say, that delinquent employee who has been penalized or who has been punished by the disciplinary authority, can go in appeal. So every organization has an appellate authority for such matters. So for such kind of you can say matters, that that particular employee or the charged official will go for an appeal, and after appeal, then after rejection of his submission in appeal, the same person can go for review by the competent authority, one level higher. You could be the head of the organization normally. So these are the stages of disciplinary proceedings. So friends, as we understand that these steps are very important to follow if we want to conclude the disciplinary matter in a successful manner. What happens if we do not follow these small steps, then the entire conduct of the disciplinary proceeding by us, they tend to fail, and they tend to be rejected by the judicial you can say agencies. So this is very important to follow. And in the last, I would like to say many important things while this following the various proceedings. There are various principles of natural justice which have to be followed, and all these principles of natural justice, they are, you can say, they are informal sayings, that we normally come across. For example, we say that no one can be punished twice for the same crime. So one of the dictums is like this. So many, like you can find, justice delayed, justice denied. No one can be punished without being heard, or everybody has a right to fair trial, all are equal before eyes of law, or so on. So these are the informal, you can say, dictums or sayings that we come across, and they reflect that you can say that principle of natural justice have to prevail anyway. So principle of natural justice, formally it has been enshrined in our constitution. So as we discussed the entire proceedings, Now, in conclusion, I'd like to make few more important points that while addressing all these disciplinary matters, we have to ensure that principles of natural justice have to prevail, or we have to keep all these principles in mind. As I said, the principles of natural justice are all people are equal before eyes of law. No one can be punished twice for the same crime. Everybody has a right to fair trial. So on. So these are, you can say, the various principles of natural justice. And principles of natural justice have been enshrined in the very much Constitution of India. Article 311 is the most important article, and this article, you can say, this is the theoretical bedrock for the entire you can say legal proceedings, and this is the main you can say the source, or the entire proceedings and all, you can say, the procedures in legal court or in disciplinary matters have the lineage, you can say, to the same, you can say, article of Indian Constitution. So Article 311 of Indian Constitution says no person who is a member of a civil service of the Union or an All India service or a civil service of a state or holds a civil post under the Union or a state shall be dismissed or removed by an authority subordinate to that by which he was appointed. So it is very much important that no person can be dismissed, removed, or punished or terminated by a, you can say, authority who is subordinate to the appointing authority. This is very much, appointing authority is the most you can say the competent authority in the organization. So it has to be taken care of. And the second, which is very much important, and in the same article 311 of the Indian Constitution says about the, you can say, it gives you the whole idea of the fair trial, or the how disciplinary proceedings should go on. It says no such person as aforesaid shall be dismissed, removed, or reduced in rank except after an inquiry in which he has been informed of the charges against him and given a reasonable opportunity of being heard in respect of those charges, provided that where it is proposed after such inquiry to impose upon him any such penalty may be imposed on the basis of evidence adduced during such inquiry. So, this is how we find that 311 is the most important article of Indian Constitution, which gives the, or which is the main, you can say, the principle of the legal procedures, and that must be taken care of or kept in mind while dealing with the disciplinary proceedings. So this way, I hope that it may give you slight, or you can say, an idea about how we can go while dealing with disciplinary matters. So friends, I have just tried to share my experience with all of you, because I find that a beginner like me, they don't find the consolidated, you can say, the literature where how a person can go in dealing with the disciplinary proceedings. So for this, I tell you that I studied Indian Constitution, various the standing orders of my organization, various conduct rules, and the interaction and verbal discourse with legal experts and so on. So thank you so much for your patient hearing. Well, friends, I request you to please do watch my slides upcoming for what I have spoken in my presentation. Thank you.
Let it go, make my body go. Take our bodies higher and higher.